I'm Caroline Willow and I'm the Director of Article 39 Children's Rights Charity. I want to talk about why my charity has threatened legal action against the Department for Education. 2 weeks ago, on the 24th of April, around 100 changes to children's social care law came into force. We count 65 separate losses or dilutions of legal protections for children in care or for children who could come into care. The government says these are temporary COVID-19 measures which will end on the 25th of September unless extended, which is not reassuring. These changes are extraordinary for three reasons. First, the shock and breadth of what's been changed. This includes relaxation of duties on councils to visit children in care, to review the welfare of each child in care, mechanisms outside the family court to independently scrutinise and check that adoption is absolutely the right thing for each child, and removal of safeguards for children who come in and out of care into what are called short breaks. That mostly affects disabled children, but other children are affected too. Even legal safeguards which support children in care being placed with wider members of their family and friendship circles have been diluted, making it easier for councils to put children in care with foster carers instead, including outside the child's home area, and that includes outside England too. The second thing that's extraordinary is that there's been no public consultation on any of this. At first, the Department for Education claimed that a small, select number of organisations had been consulted and that they'd actually asked for these legal changes. But during these past 2 weeks, one by one, organisations that were named by the Department for Education have publicly denied that they asked for the legal changes or that they were consulted on the detail. Let's remember that every legal protection that's been removed or diluted was put there because it protected and made things better for vulnerable children. Some of these protections go back to the 1940s. Thirdly, what's really shocking in a democracy is that Statutory Instrument 445, which makes the changes, was laid before Parliament on Thursday the 23rd of April and came into force the very next day. There's meant to be at least a 21-day scrutiny process in Parliament for changes like this. So not only were all the changes bundled together in one document, but parliamentarians were not given any time to review and debate the changes. These are our most vulnerable children. They are in the care of the state. How can it be right that their legal protections, carefully crafted over many decades, can be taken away on the say-so of government ministers? I've heard some people and organisations over the past 2 weeks say the changes will only be used if absolutely necessary. They've seemingly been reassured by guidance published on the government's website. With respect, this misses the point. The law has been changed. I've been in jobs and roles for nearly 30 years which involve giving children and young people in care information about their rights. For that, we have to go to what the law says. The law tells people what their entitlements are and what their protections are. It gives the bottom line, and is particularly important for people who are powerless. What if ministers had laid a statutory instrument allowing individual job centres to introduce different rates of universal credit? Or they'd allowed individual workplaces to set their own minimum wage, or their own sick pay, or their own furlough agreements? Would this be acceptable if government told us that these flexibilities would only kick in if our individual job centre or our individual workplace thought they were absolutely necessary? I don't think so. For ourselves, we'd want the law to be clear and universal and to protect everyone in the same situation the same way. Isn't that what we want for children in care as well? Whether they're in care in Newcastle or Newquay, surely their legal protections and entitlements should be the same. We've had nearly 10 years of government trying to deregulate children's social care. The biggest attempt before now was back in 2016. Then a bill was introduced into Parliament which proposed to allow councils to opt out of their children's social care statutory duties for up to 6 years as trials for removing the legal protections altogether across the whole country. But ministers couldn't persuade parliamentarians, social workers, children's lawyers, charities, including those set up and run by people who've been in the care system. They couldn't persuade us that that was justified or necessary, and they were forced to backtrack. I thought that bill 4 years ago was shocking enough, but this statutory instrument takes us to another level for the lack of respect for democratic processes. There are a few provisions in the statutory instrument which are completely understandable during this pandemic, like allowing social workers to use the telephone and video calls to visit and check up on the welfare of children in care. They could have been introduced with everyone's support. Instead, those changes have been surrounded by legal changes which the government has been trying to push through Parliament and elsewhere for years. The Welsh Government has said it's not changing its law relating to children's social care. We share the same land. There will be brothers and sisters in care who live in English and Welsh local authorities, respectively, whose legal safeguards either remain intact and untouched or weakened and diminished. It's not easy as a small charity having to push this or to threaten legal action, but it's the right thing to do. More than 40 organisations have already joined us, and hundreds of care experienced people, social workers, lawyers, health professionals, and many others have joined the campaign to scrap Statutory Instrument 445. Please be part of this defence of children's rights in care.